February 28th, and we're looking at H105, and I'm hoping to have a vote on this after we take a look at this hopefully final language that we have from Ben. Over to you, Ben.
Thank you, Chair Lalonde. Ben Novogratski from the Office of Legislative Counsel. Before the committee is draft 2.1 of the strike all amendment. It's now fully edited with the changes that were made this morning. And also for some reader assistance, I have included in the repeal section just parentheticals describing the laws that are being repealed because aspects of them are being rolled into this bill, and so they're no longer needed.
So, all right. So I'm going to go ahead just to move this along. I'll take a motion and we can have further discussion we'll first just start with the amendment, draft 2.1 amendment to H105. Is there a motion to find that favorable? Ken, is the motion, and second. All those in favor of the amendment, so we can move on to say aye or raise your hand, I guess. Raise your hand. Okay. So I'll go ahead and take a motion to find favorable H105 as amended by draft number 2.1. Is there a second? Okay. Discussion. Is it the Friday afternoon right before break? So I guess I will just say, I know that there's been different ideas, and we've been bantering around different. I know that Zach has had some things that he's wanted that we haven't quite given in on that, but there's other things that I think we've had some compromise as far as the length of suspensions. And I think that was kind of one of the key components of really the amendment as well as the reporting. But I think overall it's a step in the right direction. It's not necessarily everything that we want to have, but I think it moves us in an appropriate direction. So happy for any other discussion.
No, I'll just say ditto to what you said. I mean, it's definitely a step in the right direction, and like we do a lot. There's compromise in the bill, and which there's compromise. That means somebody maybe isn't getting as much as they want, and somebody else, on the opposite end of it. So that's not always that.
Right. Well, I think there's stuff in here that we can all be happy with. Yeah. And there's stuff in here that we probably don't like as well. Anything else?
Just call the vote.
All right, I will the clerk call the roll.
Arsenal. Dolan.
Yes.
Good now.
Yes.
Roslant, yes. Harvey.
No.
Malay.
Yes.
Sorry, 1 second. Oliver.
Yeah.
Richardson. Christie.
Yes.
Verdict. Well,
Yes. And Ian has agreed to be our DUI guy this year. So thank you for that. Ian is going to report that. So all right, thank you, Ben, for all your work on that as well. Thank you, committee. Moving that along. And
That's the last vote, right?
yeah, and we have 3 additional witnesses for H193. I'm hoping that will be somewhat expedited, and I hope I can at least keep 6 people here. But I know that you have to head out. I know Alicia, are you here for more?
I could stay a little bit longer, yeah.
So we'll start with Marshall. Thank you for being here, Marshall.
Real quick, everybody have a great week.
Yeah, have a great weekend, Tom. Safe travels as well, Tom.
And could you make me,
Oh, yes, right.
so I can share? Thanks.
You're all set.
All right, let's see here. There's a bunch of slides. So I'm gonna start this off.
Yes.
All right. So to start out with, Marshall Paul from the Office of Defender General, Chief Juvenile Defender. I was prepared for the testimony today to talk about our opinions about this bill. And in watching the testimony yesterday, I really changed my approach. And I think that we're going to need to come back to talk about really the contents of this bill, because there was a lot that was said yesterday that was inaccurate to the point of really needing correction in order to understand the context of this bill. And that was really in particular about Vermont's juvenile defense attorneys who work in the CHINS courts. So these are the child welfare courts as opposed to the juvenile delinquency courts. And I want to just start by, let's see if I can figure out how to move through slides. Start by just explaining the basics of our structure. So we have two types generally of attorneys that represent parents or children in child welfare cases. Those are either staff attorneys who are working in our staff offices, or they're contract attorneys who work in cases where our staff office has a conflict. And those are primarily what was being talked about yesterday, was our contract attorneys. And so that's what I'm going to focus on. And one of the things to understand is we have to have contract attorneys, because in a normal case, a criminal case, state versus Marshall Paul, there's two parties. I'm a party because I'm being charged with a crime, and the state's party because they're charging me with a crime. And so a public defender office can represent me, the state's attorney's office can represent the state. There are no conflicts there. There's no need for conflict counsel. Every single CHINS case involves, at the very least, a couple of parents and a child. And often it involves more than one child, and often it involves more than two parents. And so necessarily, right from the outset, you cannot have one attorney's office representing a parent, a child, another parent, potentially another parent, potentially another child or set of children. So you need to have conflict attorneys. So we have about 15 public defenders who primarily represent parents and children, and we have about 40 more contractors who represent parents or children in the same cases. These are all people appearing in court at the same time representing different parties. There's a general rule that our staff office is assigned to represent the child, but actually, and this is not, this is again some of what's contrary to what was said yesterday. Yesterday, it was said that primarily contractors represent parents. That's not actually true, because the way that we do our conflict analysis is if our office is ever represented, let's say a case comes in and it's one child and two parents, keep it simple. If our office has represented either of those parents in any way, shape, or form, in juvenile court, in adult court, in criminal court, in any matter, we're going to represent who we've already represented, because we think continuity of counsel is important. And so that actually turns out to be the case in 50% of cases. So really 50% of the time, children are being represented by conflict counsel, and 50% of the time, parents are being represented by conflict counsel. It's about a 50-50 split. It is not, as was said yesterday, primarily parents being represented by conflict counsel. So there was a number of misstatements that were made, and I'm going to go through them one at a time, and then I'm going to touch each one in detail. First of all, there was a statement made that contract attorneys are underpaid, they can't support themselves on the work that they make, and so they take a lot of extra cases. There was a statement made that contract attorneys do not have investigative resources. There was a statement made that they don't have interdisciplinary practices. There was a statement made that they're not supervised, that there's no standards, that there's no performance measures, that there's no mandated training. And there wasn't an explicit statement, but there was an implication that our office was not pursuing federal funds to expand the scope of our services. And that's why we needed a bill to seek federal funds to expand the scope of services provided. And I'll go through these statements one at a time because they're really flatly incorrect. To begin with, our attorneys are not underpaid. Staff attorneys are paid on a straight step system. You can look them up on Vermont's database of state employee salaries. They are paid consistent with what state's attorneys are paid, attorney generals are paid, so they are not underpaid. Moving on to the contract system, that's more complicated because we pay them on a contract basis, a flat rate basis for the year based on historical caseload data and trend analysis. And I'll talk about that in a minute. We calculate our caseload in terms of what we call a lawyer equivalent caseload. So that's based on how many cases should one lawyer take in a year? And then we look at their caseload data and say, if they're taking 50% of what the standard is for 1 year, then we're going to pay them 50% of our standard lawyer equivalent caseload payment. In fiscal year 2024, the average juvenile contract attorney received a lawyer equivalent caseload payment of $227,000. That's more than I make. That certainly it should be more than I make because they have to pay overhead. They have to pay the employer's side of self-employment taxes. They have to pay for some things that I, as a state employee, don't have to pay for. But it is certainly not an underpayment. It is not making it so that people are unable to continue their practices at that rate. So to look at how we actually reach that rate is complicated. And I think it's important, though, because there was talk yesterday about caseload. We measure our caseload differently in Vermont than people do in many other states. Many states do what we do in Vermont. Many states measure pending caseload. Pending caseload is easy. It's easy to calculate and it's easy to think about, but it's also not very accurate. Pending caseload is just how many cases does an attorney have open at any given time. So I could all I'd have to do is walk into my office, open my computer and say, show me my open cases, and you could see my pending caseload. We don't like using that because we think that it's not accurate enough. So what we use added cases per year. And we actually don't really use added cases per year. We use added case events per year. So for example, if we went by just pending cases, and if I had a CHINS case assigned to me, and it was a really simple CHINS case, because sometimes we get ones that are really nice and simple, a truancy case where the real problem is very easy to identify and address. It turns out that this is a child who needed special education services. As soon as we get an assessment, the problem becomes clear and the solution becomes clear, and we get it all wrapped up in a few months, and that would count as one case. We also have cases that go on for years and end up in termination of parental rights hearings that go on for a literal, sometimes a week of trial. They are incredibly intense cases. And we think it's important to weigh those types of cases differently. So that's what we do. We take the National Advisory Commission on Criminal Justice Standards has a standard that attorneys in child welfare cases should have no more than 200 added cases a year. We think that standard's outdated, so we've tweaked it. We've lowered it to 150, which is the same as the standard for felony attorneys in the criminal division. And we've also added what we think is a case. So under their original standards, every added case is one case, and that's all. We thought that it was important to identify specific case events. So we say that, for example, if a case goes to a termination of parental rights, that's a huge process. If it's contested, big trial, lots of preparation, that counts as 3 cases. So that's 3 added case events. A case that is just petitioned and then goes through disposition and wraps up pretty quickly, that's only going to count as 1 case event. If there's multiple post-disposition events, so if there's lots of post-dispositional hearings, each of those will count as a case event. So we're pretty granular about it because, frankly, there's big differences in practice between the counties in Vermont. And so, for example, somebody with a 50-case caseload in Chittenden County, I would say is somebody who could probably take on more work. That's not an overbearing caseload in Chittenden County. If those same 40 or 50 cases, if you had those in Franklin County, I would be calling you up and saying, do you have everything you need? Do you need extra help? Because in Franklin County, a lot more cases go to termination of parental rights. They have a lot more contested hearings, and a 50-case caseload is a lot more of a workload in Franklin County than it is in Chittenden County. So that's why we use the case, that's why we calculate a caseload the way we do. So how do we get to pay? Pay is pretty easy. We look at 3 years of historical caseload data and we take into account any trend up or down. And then we make some adjustments based on remoteness of the court and experience of the lawyer. So let's say, and this is a real example, I was just looking at our spreadsheet from last year. If a contract started a few years ago and you calculated out the actual caseload of that contract, then it was 0.35 LEC, and then a year later it was 0.45, and a year later it was 0.6. We're actually going to do that contract as a 0.75 contract for the next year because we see the trend is heading upwards. Then we multiply that fraction against our target per LEC rate of 185,000 per LEC. We make adjustments using the level of experience, willingness to work in remote regions. It is hard for us to get contractors who want to drive to Orleans County, Caledonia County, Essex County. So they end up getting paid more because they're willing to make that drive. We also pay more if you are a more experienced attorney. So in this case, we ended up making a per LEC payment of about $206,000 a year, which was a $155,000 payment because they're working 0.75 LEC. At the end of the year, we look at the actual caseload data. We compare it to our projected caseload data to see how good we did at projecting. And we use that to guide our future forecasting. So like I said, our average per LEC payment in FY24 was $227. So from our perspective, the statement that our contractors are underpaid, that they're not able to run a practice is just flatly incorrect. Another statement that was made is that contractors don't have investigative resources. It just isn't true. I know that because my job, in part, is to approve requests for resources. So when people request an investigator, I get a notification and I have to say, I approve 20 hours at $50 an hour for an investigation in this case. CHIN's attorneys have every resource that's available to criminal attorneys, including a few that are not available to criminal attorneys. They can and do use investigators all the time. They also have access to any kind of expert you can imagine. Psychologists, psychiatrists, medical professionals, computer forensics has suddenly gotten to be much more common in the CHIN's world. It used to be that I never got a call for a computer forensics person in a CHIN's case, but now with social media and everything, that is now a feature of every case. So I'm approving experts in computer forensics. There is no limit to the list of providers that can be requested. If somebody calls me up and says, I have a case and I think I would benefit from having a statistician come in to talk about the statistics of removals in Vermont by race, they can request that. And I approved that in that case. So in terms of the idea that there's not investigative or other resources, there absolutely is. And in fact, it's probably 15% of my job is approving those requests on a daily basis. So it happens a lot. There was also the statement that CHIN's attorneys do not have access to social services providers. And that's important because I think we all do agree that the interdisciplinary model of practice really is the gold standard. That's what we're all trying to achieve. I think the interdisciplinary standard as it was described yesterday was really an incomplete definition. The way that I think Mr. Chris described it was that it was a practice that has an integrated social worker in it. I think there's a lot more to it than that. When we look at what we are doing as trying to have an interdisciplinary practice, and we look at it as far more than simply having social workers available. It's also having landlord-tenant attorneys available. It's having education attorneys available. It's having caseworkers available. It's having case managers available. It's having immigration attorneys available. It's having translators available. It's all of that, really providing a holistic defense to the client. One of the ways that we've tried to do that within the constraints that we have is through our family support worker program. And that is a very successful program. We've got more than 24 family support workers scattered all over the state who provide all manners of social services. Sometimes in a case, what you really need isn't really any detailed sort of, intensive social worker support. Sometimes what you need is somebody to act as sort of a neutral buffer so that when you have a client who is experiencing like the worst days of their lives, and they have to go to their first meeting with a DCF social worker, and they have a lot of hostility toward that social worker, and we can bring along another social worker who works for us and who is on our client's team to try to help guide our client through that interaction, to help them process that interaction afterwards. It's incredibly valuable. And I will say, when we started this program about, I want to say 12 years ago, it was not necessarily viewed without suspicion. There was times where DCF was opposed to having family support workers involved in processes. There was times when attorneys were suspicious of it. There was times when prosecutors tried to have our family support workers removed from the courtroom. Years of success of the program has really built to the point where it's now just an accepted part of the process, and everybody works well with our family support workers. Not that there's not the occasional hiccup, there always is in any system where you have a lot of people, but for the most part, our family support workers work really well with DCF, with all of the external providers, and with our clients and with our attorneys. And they are available to every attorney who wants one. I am not aware of, the only time we turn down people's requests for a family support worker are when they're asking for a family support worker way too late. There's studies that have shown that having social workers on the defense team is really a benefit early in the case. But if you wait till a TPR has been filed and then ask for a family support worker, we're likely to say no, because there's no benefit to that. You're not going to fix the case that late in the case. But for the most part, we provide that to every attorney, contract or not, and we do not say no to anybody in their request for family support workers. So the idea that we are not providing that service is just incorrect. And our family support workers are a great group. The largest group of them are actually former DCF workers. We also have several kind of semi-retired licensed clinical social workers who wanted to keep working in the social services world, but step back from full-time practice. And then we have a bunch of sort of anybody who has skills that could help our clients. We have one person who's a former special educator who is fantastic in education-related cases. She can work with the schools better than anybody else can. We have one woman who's amazing. I don't actually know, she doesn't have qualifications, but she can find housing for anybody when there's no housing available. And I think it's honestly just because she's connected to a really large church. Anybody who goes to the church probably knows her. And she just harangues people. When we have a client who needs housing, she will go and she will find somebody who's got a basement apartment or a mother-in-law suite or something, and she will badger them into taking our client in. And she's just a miracle worker when it comes to housing, but not that she has any particular training in social work, but just, so we'll take anybody who's got those skills and we use them effectively. And a lot of our attorneys develop a relationship with one particular family support worker or another, and use those family support workers exclusively. And we have attorneys that have family support workers embedded in their offices. So the idea that we do not have interdisciplinary practice in Vermont is just simply false. We have interdisciplinary practice in our larger offices. It's embedded into the office. In our smaller offices, it's a case-by-case basis, but we don't say no to people. Services get them. The idea that Vermont attorneys are not supervised is also incorrect.
Can I ask a question? I don't know. Is that what the testimony was yesterday? That Vermont attorneys aren't supervised, or was it specifically that the contract attorneys in the CHIN's realm are not supervised? So
like I said at the beginning, we've got the staff and the contractors. The comments yesterday focused on the contractors, so my whole presentation.
Okay, oh, so this is
Focused
just,
on the
okay,
contractors. Staff attorneys are not making $227,000 a year. I wish we were, but we're not.
Okay.
This is all focused on the contractors.
okay,
So Vermont, contract attorneys are supervised. Obviously, we don't manage their work on any individual case. We don't do that to staff attorneys either. That would be really contrary to the professionalism of law, which is that the individual attorney takes responsibility for the individual case and client. We do absolutely supervise all of the attorneys in the sense that we respond to any complaints that are brought by parties, judges, or collateral contacts. That's something we take really seriously. That's probably about 25% of my job is handling complaints. Every complaint is investigated. We order transcripts if there's any indication that there was problems that happened in the courtroom. I interview judges, I interview clients, I interview other attorneys, I interview courtroom staff. When there's a complaint about one of our attorneys, we investigate it and take it really seriously. We have the fewest complaints about our juvenile attorneys. I get far more complaints about our criminal attorneys than our juvenile attorneys. The complaints that were described yesterday by Mr. Chris, we don't hear. I'm not sure why that is. I know that his organization holds themselves out as taking complaints about the child welfare system. I would have assumed that if those complaints were coming in and were valid complaints, that if they were complaints about our attorneys, that they'd be referred to our office, because we really do. We address those complaints very directly with our attorneys. Those complaints have resulted in the termination of our attorneys. They've resulted in the termination of contracts, and they've resulted in a lot of corrective action, and they result in a lot of changes in how we train our attorneys. If I get a lot of complaints about different attorneys about the same thing, that's probably a sign that it's not an attorney problem, it's a training problem, and we adjust our training. So it's just not true that Vermont contract attorneys are not supervised. The idea that there's no standards for Vermont attorneys, also just not true. There's two sets of standards for attorneys that represent parents and children. The ABA has one set of standards. The National Association of Counsel for Children has another set. In Vermont, our office has chosen the ABA standards as what we train on. But because there's two sets of standards, and because it's not like the state of Vermont has ever adopted one or the other, and it's not like the Vermont Professional Responsibility Board has ever said, yeah, we choose one or the other. And the differences between the two are very minor. They have to do with the ethics of representing children. We teach the controversy. So we teach people basically, here are two sets of standards. These are the standards you have to follow. If it comes to this point where these standards disagree, just make sure that you're doing something thoughtful. You're following one standard or the other, because they're both doing the right thing. They're both trying to accomplish the same thing. They're both doing it in different ways. I could get into what the difference is, but it's nitty-gritty details about the ethics of representing children that we don't need to get into. But so it's not correct to say that we don't have standards for attorneys in Vermont. We use the ABA standards. Those are the most commonly used standards across the country. The idea that there's not standards for practice in Vermont is just incorrect. That leads us to the next thing that was said, which is there's no performance measures for CHIN's attorneys in Vermont. That's totally incorrect also. We do attorney evaluations on a 3-year cycle, usually. I'll get to the usually in a minute. We do that because we see them mostly as providing us benefit in deciding how we structure our trainings. And we see training as sort of a 3-year cycle. Find out about a problem, you train about it for a couple of years, you reevaluate. So we do 3-year trainings. We missed our last one, and that's because it fell in 2021 when the pandemic was going on. And actually, more significantly than that, we switched case management systems from Justware to AdvoLogix. And in doing so, we lost our ability to do the judicial evaluations. So these are evaluations done by judges, because judges see all the attorneys, they see practice in multiple counties. And so they really have the best ability to judge attorneys' practice in terms of how it stacks up against other attorneys. And what those measures show is that our attorneys are doing really excellent work. I'm not going to go through every one of these, but I'll upload this PowerPoint and everybody can look at it. These are the last ones that were done. This is in 2018. This is only looking at contractors, not looking at staff attorneys. And it's only looking at the judicial evaluations, not peer evaluations. 6 is considered very good. 7 is excellent. 8 is preeminent. That was designed with the idea that we'd have a few attorneys who achieved 8s and that most people would be lower than that. And so if you look at these, we get pretty granular. This is about motion practice. Do you not understand the rules? Do you understand the law? Do you file the motions appropriately? And are you appropriately prepared? Our contract attorneys over the course of 3 cycles, 9 years, pretty much hovered right around very good. Same is true when you look at effective representation. So this is understanding the best disposition, understanding the client's needs and the family's needs. Different variations on that, all hovering around the very good standard. Same when it comes to courtroom skill. Courtroom skill, there's a lot of questions about familiar with the facts of the case, effectively represents the client, communicates with the client, cross-examines, does the courtroom stuff well. There we, again, hover around between good and very good, with things kind of trending up over the 9-year cycle that we're looking at. Client relationship, in terms of our attorneys, knowing our clients, being familiar with our clients, being familiar with our clients' needs and the fact of the case. Again, hovering between good and very good. Professionalism, again, hovering between good and very good. You'll see there's some in there where there's not 3 bars. That's because that's some of those questions we added in 2014, so they weren't included in the first round of questioning. But again, our attorneys score very highly. So the idea that there's no performance measures, entirely false. We very much have performance measures. Those performance measures are used for 2 purposes. One is for HR. I mean, if we get somebody and their performance stands out because they're getting a bunch of 2s or 3s or not very good scores, we're going to have a serious conversation with that person about whether they're going to continue their contract and what they are, if not, what they're going to do, and if so, what they're going to do to improve. That's actually the least common way we use it, because usually if we have somebody who's having that kind of trouble, we hear about it long before these 3-year performance evaluations. More what we use this for is to guide our training. So, for example, you can see that in 2010, we had a sort of low score on working efficiently and meeting deadlines. That became a training focus for us for the next few years. And you can see we bumped that number up a little bit. So again, the idea that there's no performance measures, absolutely false. And in fact, our contract CHINS attorneys do well on their performance measures. There was also a statement that there was no mandated training for CHINS attorneys. That's totally false. It's written right into every CHINS attorney's contract. If you want to have a contract, you have to come to training. That is enforced pretty rigorously. We make exceptions for people who have medical conditions or, a death in the family or something. But other than that, you have to come to training. You can't just skip training. And our trainings are more rigorous than what's offered, to my knowledge, anywhere else in New England. I don't know about the rest of the country, but we have a group of New England chief juvenile defenders that meet on a regular basis. If you talk to people in New Hampshire where they don't have public defenders that provide representation in child welfare cases, and it's all done by ad hoc attorneys. I was doing an interview with attorneys over there once, and I asked how often they had training. They had never had a training on child welfare representation. We have a guaranteed 3 full days of training on child welfare representation every year. Sometimes we have a 4th, depending on our budget. Our summer training is either 2 or 3 days long, depending on our budget. And in addition, we have regular 2-day-a-month online trainings over Zoom. Those trainings are not mandatory because people's schedules are what they are. So we're not going to tell people you have to be here at noon at lunchtime when people can't do that. But we regularly have 50 to 80 attorneys on each one of those Zoom trainings. So the idea that there's not mandatory trainings is not true. We have the most extensive mandatory trainings in the state or in the region. And we also have optional trainings that are available twice a month. And those trainings really are CHINS focused. So we go into our trainings, there will be two tracks. There will be a criminal track and there will be a CHINS track. And the only times that they intersect each other are things that apply to both. So for example, we did a training a while ago on introducing social media as evidence. That's really applicable to both CHINS attorneys and criminal attorneys. So that was one that really everybody sort of converged for that. But we're talking about 3 days of dedicated juvenile training that's required for anybody who works for us as a staff attorney or who has a contract. Finally, there's an implication that what the point of this bill is to come up with a plan to draw down federal funds to expand Vermont's child welfare defense offerings, in particular to include interdisciplinary representation. Nobody's ever, and this is one thing I want to point out about all of these misstatements, nobody's ever asked us. Nobody from Vermont Parent Representation Center has ever come to us and said, how much do you pay your attorneys? Or even FOIA'd it. I mean, this is all public information. You could just FOIA it and we'd have to send all our spreadsheets and everything. So nobody ever asked us, like, do you need this? Is this something that, do you need Title IV money? And if so, what would you do with it? So at the end of 2018 is when the Federal Agency of Human Services made Title IV money first available for parent and child representation. We were on that like first thing. I mean, when that news came out, we had a call between all of the chief juvenile defenders in New England talking about how we were going to start accessing these funds. Our office started working primarily with the Connecticut Chief Juvenile Defender's Office because they have a structure that's similar to ours. They wrote up a memorandum of understanding, we copied theirs, and worked together with DCF to come up. They agreed to, with our, we bounced back and forth a memorandum of understanding, came to an agreement. The plan was that it would draw down money for three primary purposes. One was to increase interdisciplinary practice by increasing our use of, I would call them social workers. I shouldn't have said that. Family support workers. Shouldn't use social worker to describe anybody who's not actually a licensed clinical social worker, but our family support workers. And embedding more family support workers in our larger offices to fund collateral representation, including landlord-tenant representation, immigration representation, education representation, and to create a pre-petition representation partnership between our office and hospitals to be able to provide legal services to people who are identified as being at risk of DCF intervention early on. These are the kinds of things that were discussed yesterday as sort of the elements of interdisciplinary practice, and that you were told we needed to have a committee to form to try to figure, this is what we were doing in 2018.
So you are drawing down those money?
Not yet, we'll get to that.
Okay, all right.
But we tried to in 2018. Then what happens is, so it was fruitful in the sense that we came to an agreement with DCF, that it was an agreement we were pretty sure was going to get approved by AHS because the very similar agreement from Connecticut had gotten approved and we had modeled our agreement after that on that one. So we were pretty sure that we were in a great spot to get that approved. And then we were told that because of DCF's antiquated software system, we wouldn't be able to identify the certain cases that needed to be identified in order to draw down those funds. And so we sort of shifted our focus from trying to draw down those federal funds to trying to support DCF's requests for money and funding to improve their computer system so that we could draw down those federal funds. In 2024, we found a private company that we are currently working with. They're providing services to a bunch of other jurisdictions that have the same problem that we have, which is antiquated computer systems and an inability to do the kind of reporting to the federal government that the federal government requires. And so we've had several productive meetings with them and included DCF in one of those meetings. And the plan is for that firm to essentially take on the reporting requirement and do that work that DCF's computers can't accomplish so that we can draw down those funds. And we anticipate that process will be successful. They've been very successful in a bunch of other jurisdictions, so we don't see why they wouldn't be successful here in helping us to accomplish that. So part of what I see when I see this bill is we're already like 10 steps down the road that this bill is starting to create a first step for. Like we already developed a plan to get those federal funds. We ran into our first roadblock. We've now come up with a possible solution that gets us around that roadblock and looks pretty promising, given that that's been a solution that's gotten a bunch of other jurisdictions over that roadblock. And what we would intend to do with that money is exactly what this bill is intended to address. We're a little frustrated in the sense that nobody came to us and asked us about this. Nobody came to us and said, you know, what do you require for training? Like nobody ever asked us, if somebody asked us, can you provide us your training agendas for the past 10 years? We would provide that. We've got all that and it's publicly, it's public information request. We have to provide that. If somebody asked us, can you provide us with a copy of a contractor's contract? We'd probably have to redact some of the HR sensitive stuff in there, but the boilerplate parts of it that include the requirement that you attend mandatory training, they could have that if they requested it. Nobody ever asked for it. The idea of us not having performance measures, nobody ever said, do you guys have performance measures? And if so, can we see them? Not only are these public, I got these off of the legislature's website. We've presented this data in the legislature dozens of times.
Okay.
So you're here now. Why don't you let us know what you need?
Right now,
I mean, because we're just hearing like rebuttal from yesterday and it's like, okay, I want to get from point A to point B. It's like,
right now, we don't need anything. Right now, the work that we are doing, I don't think we need anything legislative. I think we need things that are administrative. And that's just work. And we're doing that work. We are working with this private company to help to draw down those funds. In order to draw down those funds, we have to have a plan. We know what our plan will look like because we already developed it before. And we've sat and thought about whether our priorities have changed since we developed it. And really, they haven't. We really still see those three as being the kind of most obvious needs to be addressed. So we would say we don't need anything right now.
so have you been in touch with the parent-child center or whatever they're called to like go and so there's been total lack of communication between both of you.
Yeah, I mean, honestly, they're a really small organization. In my career, I worked on one case that Vermont Parent Representation had worked on, and that was more than a decade ago, back when I was practicing in Lamoille County. They had not reached out to us about this, and if they had, I mean, we would have not only would we have given them all that information, we wouldn't even have a choice. This is all public information. It's just that nobody's asked for it. We have a lot of information people can ask for. All state agencies do. We generate information like crazy, and except for the stuff that we generate that's HR related or related to a case or falls into one of the other exceptions, it's all publicly available.
Well, maybe my thinking here is kind of crispy, but it just seems like it's like we're both of you are like there's got to be communication between what both of you want, or maybe you're coming, I don't know, I guess you're coming before us and telling us, but I mean, how can we have? I guess is direct question.
The ways that you could help is, I do think that legislatively speaking, one of the big needs we have in the chin system, and I think pretty much everybody would agree on this. I can't speak for everybody, but I've had so many informal conversations that I think everybody would agree that it really is time to devote the time to a real reexamination and rewrite of the CHIN's chapters. It's been almost 20 years since the Juvenile Proceedings Act was passed in 2007. That was the last big picture reexamination and rewrite of the CHIN's chapters. And I think that over the last 20 years, there's a lot that we all know works well and a lot that we all know is cumbersome and difficult. And also just the practice of child welfare across the country has changed, and it's time for us to kind of keep up with those best practices and reevaluate the system. We would be very supportive of a bill that created a committee to really like they did back in 2007. It was a 2-year project to rewrite the CHIN's chapters. But we think it's time to do that again. And that'll be a heavy lift, and it sucks to bring that up because I'm saying that, and I know that I would be the one from my office that would be tasked with doing it. And I know it would be an insanely resource intensive thing, but it's got to happen. So I think that would be one thing that would be really tremendous for the legislature to kickstart that process. We all know it needs to happen, and we're tinkering with it in different ways. We have a group right now that includes TCF, our office, prosecutors, that's just working on the problems with confidentiality. Our confidentiality statutes in Vermont, in CHIN's code, are so difficult and cumbersome to work with that literally everybody in the room agrees you can't actually always comply with them. You have to violate them in order to do their job. Like TCF has to violate them, we have to violate them, prosecutors have to violate them. And just that process of trying to tinker with those 2 statutes to make them say what we want to say is taking us months and months and months. So it's really going to be a dedicated effort, and it's going to be a lot of work for a small handful of people, but we think it needs to happen.
So the Chief Justice is one of the main sponsors of this bill. And again, nobody's reached out to either side, what I'm hearing from you, right? And then it's coming before us. It's like, I feel like I'm in, I can't believe I'm going to say this, but litigation here.
And
Why hasn't both groups reached out to each other and then brought something to us that maybe we could do something about?
And from our perspective, it's because in some ways, we're blindsided by this. Like, we did not know this was coming. When we saw this bill, we read it and we were kind of shocked to read it because it didn't, from our perspective, reflect the reality of what was happening. And then, so we were prepared to come in and simply say, we're already doing what this bill is trying to accomplish. And then to hear the testimony yesterday that just had so many inaccuracies about what the system actually is and how it functions really gave a perspective, which is, oh, the reason why this bill is the way it is and doesn't reflect the sort of reality on the ground is because it was drafted without an understanding of how the system works and what's functioning and what's not.
I'm going to leave it here because I sitting in this chair, I feel like a machete's being thrown at me. I mean, I don't take it personally, obviously, but it's like,
Not throwing anything.
no, I didn't mean that, but what, I hope between over break or whatever, I hope somehow or another there's communication that starts. Maybe we can have a better understanding of really what's going on, and the lack of the communication between both groups, because you've said you were blindsided and stuff, and it's like, well,
To be
I'm
frank,
just like,
I'm not sure that the communication is going to be effective. I mean, there was discussion yesterday about how this bill was similar to a bill from 2018. That bill from 2018 said that it was directing the legislature to create a committee that did not include the Office of the Defender General, to create a system of representation that did not include the Office of the Defender General. This is very much targeted at our office. That's why, I mean, I shouldn't say that.
So a personal
I'm not gonna
attack?
speculate. I'm not gonna speculate.
I mean, an office attack?
I'm not going to speculate about the motive behind the attack, but it is an attack on our office. And it's, the report that was written by the Vermont Parent Representation Center was incredibly critical of our office, but the criticisms were conclusory. They didn't cite to any sources. I don't think this is a situation where effective communication is the problem. I'm not sure exactly what is the problem because I have sort of just stumbled into this role. It's not, whatever the animosity is there, it's not something that I was part of creating. It's something that existed before my time. But from our perspective, and to be fair, and I want to just make this clear, we don't actually have, I'm a little bit frustrated with this bill and some of what was said yesterday, but we don't have animosity towards the Parent Representation Center. We actually refer clients to them from time to time, and we've gotten clients who have come to us, referred to us by the Vermont Parent Representation Center. So we don't have a real sort of structural animosity, which is part of the reason I was so taken aback by the testimony yesterday and came in today really feeling like what I needed to do is clarify a lot of the statements that were made yesterday.
Got it. Thank you.
Tom, Karen, Ian,
First, I think maybe Ben wants to hook up with you and get a contract signed. Other than that.
maybe I should get my license.
Yeah, there you go.
So, that's to be emeritus,
I was shaking yesterday during the testimony.
I don't want to, can I interrupt for a minute? I don't want to give too much of an impression that
No, no.
227,000 is a huge amount. These are people, what we are expecting of our attorneys at that level is that they are practicing at a high level, that they are practicing, they're running their own firms, they have a lot of overhead. And one of the things I didn't mention, I probably should have put in a slide. I did go through all of our contractors and looked at their years of experience. This might be the most experienced bar in the state. I found like one attorney who only had a couple years of child welfare law experience. Before that, he'd been a criminal attorney. Everybody else was 8 years plus. And we have people who have been doing this work for 38 years. That was the highest. So we have an incredibly experienced bar doing this work. And so that's part of the reason why $227,000 as an average per LEC payment may seem like a lot, but when you put into, running a law practice and the amount of experience that these practitioners have, I'm not saying that they're not underpaid, but it's not an exceptional.
I wasn't meant to be a dig like that, actually. Anyway, but it's hard work, definitely. I've watched them in the firm. My two things came to mind yesterday when you listened to their testimony. One, I was kind of surprised about how many why are so many TPRs popping up or in certain places? I was having a hard time grasping, why would a smaller population area have a higher rate of TPR than a larger population? But anyway, that aside, you're also operating regarding the complaint side of it. If anybody was operating in that capacity at a rate less than satisfactory, I'm assuming it would be, even if they did it once or on one little issue, I think it would be picked up on and dealt with rather rapidly on its own, just knowing all the players that are in the room are your attorney's practicing, there's a judge, but everybody's judging what's going on. So that's sort of its own first defense right there.
That's definitely true. And I'll tell you that that's a difference between criminal and juvenile court. So I take all complaints. Most of my complaints that I get about criminal attorneys come from clients or from clients' families. Most of the complaints that I hear about juvenile attorneys come from other attorneys in the courtroom.
Karen.
My questions have been answered. Thanks.
Yeah, I think have all of mine been answered. Only thing I was going to note was the witness who gave the testimony yesterday about the lack of standards. I'm pretty sure came into that role in 2018. So it is interesting, like I wonder if that's an element of this communication that the last time you guys had a thing on this was 2018, and then, yeah, I don't know. I'm just sort of like, I'm pretty surprised at how contrary the testimony is between today and yesterday. So I'm just trying to understand. And I guess if there's been no communication, I'm wondering if that's part of it too, that like, you've been collecting that data, you just haven't analyzed it since 2018?
No, when we do one of these, it's a big project. So what we have to do is we have to set up, and the way we used to do it using our case management system is we could set up a unique page for each attorney.
Yeah,
We would identify which judges that attorney had appeared in front of during the last 3 years. We would then send the questionnaire so each judge would get inundated with fill out a request, evaluation of this attorney, every attorney that appeared in front of them with some regularity. Like, we didn't take, if you just sat in front of somebody once, that didn't count. But if it was a judge who was sitting in a county where you were practicing,
yeah,
then we collected their feedback. And as you see, under each measure, client relationship, there's actually 4 different sub measures. So it's pretty granular.
yeah.
And so it's a big deal. And that's part of the reason we only do it every 3 years, because if we did it every year, judges have refused to participate because it's too much of a burden. Because it really, you're going to get, as a judge, you might get 30 or 40 of these to evaluate.
Do you feel like, so when's the next one that you're gonna do?
As soon as we can figure out how to make our new software do it. It was switching from Justware to AdVologics. When we were in Justware, it was easy to use that system to create these individual pages so that we could have these, individual links so that people could do. And we haven't figured out how to do that with AdVologics yet, but if we cannot get our case management system to do it, then we are going to find some alternative provider that can give us the same thing. Everybody's got computer problems. That happens to be our little computer problem at the moment.
And based on the complaints that you've received, and your responsibility for keeping your finger on the pulse of this.
Yep.
Do you have any reservations or concerns that when you do eventually do this evaluation again, that your next bar is going to be somewhere drastically different than where these ones have been?
I don't think I could predict that because, like I said, these are judicial evaluations, and my complaints generally come from either clients or other attorneys.
Yeah.
And so I think they probably identify different things. What I would say is this: you wouldn't be surprised. The most common complaint is I called my attorney and they didn't call me back. That's actually usually a really easy one to resolve. I call the attorney and I say, you have a client who's calling the office and saying you didn't call him back. Can you please call him back? And in the future, please make sure you return your calls in 48 hours. And that usually resolves it right there. Some of them get more complicated. Some of them, we do end up I can't hire an attorney from a case. Only judges can assign or remove attorneys. But I do, if we have somebody where a relationship with an attorney has really broken down, or the attorney is really performing in some way that is inappropriate, we will step in and give the person instructions on, here's how you go about getting a new attorney. And if this doesn't work, call us back. So we are very open to responding to those complaints, and it's part of what we do all the time.
Just a couple more. Average caseload, number of cases for a CHIN's contractor?
Sure. There's no way to say because the contract system is a little complicated, as I'm sure you understand, but other people might not. So the way the contract system works, just to keep it simple, is like a series of waterfalls. So there's a pool at the top, contract number 1. There's a smaller pool below it, contract number 2. A smaller pool below that, contract number 3. Small pool below that, contract number 4. The case first gets assigned to contract number 1. If they can take any of the people in that case, they take a person in that case. Any conflicts spill down to contract number 2. Any conflicts from that spill down to contract number 3. So the contracts get progressively smaller as you go down the list. So the people who have the lower tier contracts are going to have fewer cases and get paid less. And the people who are at the top of the list are going to have more cases and get paid more. So there's no real way to say average number of cases per contractor. What I would say is that I took a few of our contractors who I know work pretty much full-time. We pay them like full-time, and I know they don't really take private cases, so they really are dedicated to the juvenile docket. And I just looked up their pending caseloads, and those ranged from 40 to 70.
And we heard yesterday that they testified that there are contractors who are taking on multiple CHINS contract cases. Is that the case?
Absolutely. I mean, like, for example, when I was a starting out attorney, one of my contracts was the last in line contract in Orleans County. So I was the one that they would call if there was literally nobody left to call and they still had clients who needed an assignment. And I got $400 a month for that. And so absolutely, if you have a contract like that, you're not living off that. You need contracts in other counties as well. And that tends to be the way it goes. If you're a new attorney, you start off with the lower tier contracts where you're probably going to have multiple contracts in multiple counties in order to piece together, enough money to make a living. Because being sixth in line in Orleans County, I actually never got a call. I got my $400 every month for taking any call that came in, but I never got a call. And then they canceled my contract because that's what they do whenever they have a contract where they get zero value from it, is they cancel it for the next year.
And then my last question is, I didn't realize that that's how the CHINS that's how it worked with the contract. So in the criminal version of that, some of the cases that drop like a stone down the last contract, conflict counsel are like can be very
Yes.
yes.
So being last in line in the contract system
Yeah.
is, I mean, I don't want to say this out loud.
Nobody's listening.
You're kind of getting taken because
Yeah, you get these great.
it's the fewest number of cases, but it often is the most difficult clients. It's because there's conflicts that develop because of legal issues, because, there's times when I pick up a case and I'm going to take the case and when I look at the affidavit and I'm like, oh, I've represented that person before. I can't take this case. Straight legal conflict. Then there's conflicts that develop because you have very difficult personalities, and that causes conflict sometimes, which cause attorneys to withdraw or clients to fire their attorneys. And so those clients often wind up at the bottom of the conflict pool for the attorneys who are taking the fewest clients, but they can be the most sort of high conflict clients.
So in the criminal conflict contract, is that also happening in the CHINS?
Sure.
Okay.
Okay. So just the big picture, and we're going to go to the next witness, is I understand that there's these parties who are saying that the Defender General shouldn't be doing this. And as an excellent defense attorney, you have just mounted a very good defense, and we just still have to kind of figure this out. But I'm not sure exactly where this leaves us on this, but I understand where you're coming from. And
Can I just one more thing that I skipped over?
if it's quick,
It is.
because I'm about to lose people.
All right, Representative Oliver had just mentioned, and I didn't address it, why Vermont has such a high rate of terminations of parental rights. I actually agree with Vermont Parent Representation Center that is an issue that's problematic, and we really need to study in more detail. There's been one study that looked at it, but I don't think came to any very clear conclusions. And here's the thing, that the point that I would make about it is when you look at states that have high rates of removal and high rates of termination of parental rights, what you see are also other statistics that correlate to high rates of abuse and neglect. So you see low rates of educational attainment, high rates of childhood poverty, things like that. What's weird is that in Vermont, we sit up with all of these states like Mississippi, West Virginia, when it comes to rates of removal. But when it comes to these correlating sort of indices of child maltreatment, we're all the way at the bottom. We have some of the lowest rates of child poverty. We have some of the highest rates of educational attainment. So we do think that there is some disconnect there, that what we see reflected in our termination of parental rights and removal statutes is not really an accurate reflection of the amount of child abuse and neglect that is happening in the state of Vermont. Did that answer your?
Yeah, it's just gonna make me ask more questions.
I think this will be an ongoing discussion.
Yeah.
Oh, we're not meeting to resolve it?
We're not gonna resolve it, I don't think today. Yeah. But we are gonna get some more testimony though. So I'm excited to hear from DCF. Brenda Gooley, thank you for being here this Friday afternoon. And sorry that, well, we're gonna make Bill Young be between us and a week of vacation. Not to put any pressure on you, Bill, to figure out how to pertinent testimony coming up. But in any event, over to you first.
And just for the record, Ben Obrowski, as much as I appreciate Representative Oliver's concern, I'm very happy with my job.
Fair enough, fair enough. Take as much time as you want as well, you know, and so. If you could identify yourself for the record and proceed, thank you very much for being here.
Thank you. Good afternoon, Brenda Gooley. I'm the Director of Operations for the Family Services Division of the Department for Children and Families, where I have worked for the past 28 years, the last decade of which has been in the role of Director of Operations for DCF Family Services Division. And so it has been part of work that I have participated in over the past decade, looking specifically at the quality of representation for children and families in CHIN's proceedings. And so in 2017, the Administration for Children and Families, Children's Bureau, published an informational memorandum that spoke to an expansion of states' capacity to draw down Title IV funding for the purposes of investing further in quality representation for children and parents in CHIN's proceedings. And this is something that, you know, when the Children's Bureau published that informational memorandum, that came out of work that is done at the federal level in all states across the nation that is basically a quality assurance process. So every 7 years, the federal government comes in and conducts reviews of cases in states and then makes certain recommendations for improvement of outcomes for families served through those proceedings. I point this out as a way to say, this is not a Vermont issue. This is a national issue that at the federal level, there was a decision to invest in a more robust manner in supporting states to be able to make these improvements. And so I will say on behalf of DCF, we are in support of this bill, and we feel it is needed, that it would be very helpful. And I'm going to emphasize why as a way of overviewing the journey over the past 8 years, trying to move forward with some of this work. So back in 2017, we received that IM, we took a look at it, we said, yes, this looks like a wonderful opportunity. Certainly, we would like to draw down more federal money to support the state of Vermont to invest in the work that we're doing in serving vulnerable children and families, in being able to have safe reunification and timely, safe permanence in households. We brought the informational memorandum and the opportunity to the Justice for Children Task Force. I was a part of work that was done over several years, particularly from the 2018 to the 2020 timeframe, taking a deeper dive into this opportunity, what would be needed, and what the barriers were that we needed to overcome, drawing down those additional funds. I was a part of the work, and I would say, you know, very proud of the fact that we were able to get to the point where we had a draft memorandum of understanding between the Department for Children and Families and the Office of the Defender General, specific to drawing down these additional funds. Through that 2018 to 2020 timeframe, we learned that there actually are some unique things about the state of Vermont that make it easy to put this in place. One aspect is we are a state administered system. meaning that we have one statutory child protection agency that oversees all of the work across the whole state, and a benefit that we have one Office of Defender General that is overseeing all of the public defender work in all of these cases over the whole state. So that actually paints a picture of simplicity to develop an agreement between those two entities to be able to have this additional work. So through the Justice for Children Task Force and Court Improvement Project work, we participated in technical assistance from the Center for States for the courts. And we looked at the New York City model. I think we had good common ground that a multidisciplinary approach, similar to some aspects of which are already in place in Vermont that include the family support workers, peer support model, opportunity to have increased support to parents to demystify the court process, provide them with some information so that we can more timely get through proceedings, was something that I think was good common ground. And so we saw states across the nation start to begin to be able to put this additional funding in place for the states and wanted to duplicate it here in Vermont. And then I would say, similar to testimony you've already heard, we started to run into some barriers. Not surprisingly, it is true that the state of Vermont Family Services Division has an antiquated database, not just an antiquated database, but our social services master index system was developed in 1982. It is the oldest database in the nation. We are in the process of, we have a request for proposal coming out soon for a comprehensive child welfare information system, also known as CWIS. We have some funds, we have $15 million of matched funding in support of that CWIS system. We probably need upwards of 40 million as a state to fully to be able to move forward with that level of database. That said, again, similar to testimony that you have already heard, it's possible we don't need the CWIS database to be able to draw down those funds. What we do need is a lot to be developed. And I would say part of why we are in support of this bill is we're talking about moving multiple systems, multiple bureaucracies, multiple branches of government to come together around something that is difficult to do. And so to have the working group as a point of accountability that says this is a priority focus for these different agencies and departments is helpful. I do think we probably need to develop a system that looks at what are those eligible activities being performed by attorneys and social workers and family support workers and guardians ad litem. So there's many eligible activities, but we need to know of all of the activities that are happening, what percentage of those activities are actually FORI eligible, right? Then we need to look at who are the children being served and are those children FORI eligible? And then we need to look at the rate that gets set. So a very simple way of saying it is pretend the total amount of general fund we had to work with was $1 million. Right? So if all of the salaries of the Defender General's office and maybe other salaries were all put into a pot of money, only a percentage of that, let's say it's 75%, would be eligible activities, right? And then the children and youth that they're serving, only a percentage of those, let's say it's 40%, are eligible for FORI drawdown. And then there's actually another cut, so to speak, that needs to happen. So by the time we're drawing those monies down, we're probably only drawing down like $200,000, right? That said, that's still good, right? That's $200,000 in the state of Vermont that we otherwise wouldn't have. But we need to put those systems in place. It's not an easy thing to do. So again, I think it requires not only the will, but the investment across departments, agencies to engage in that work and, come up with something that that really passes the straight face test when it comes to working and reporting back to the federal government. Because we get audited, the money has to flow through DCF because we are Vermont's statutory child protection agency. We get audited on the $40 that we draw down. And if we get it wrong, not only do we have to pay it back, we have to pay it back across the money that we draw down, right? So we have to get it right. We have to do it properly, and it's a significant investment. And that is, I think, part of what did get us hung up back in 2020 was how do we proceed with this? It felt like a pretty overwhelming undertaking at the time. And 4E is the main federal funding stream that funds all of the child welfare work that we do, right? So our family services staff salaries, the foster care payments that we provide, the training that we provide to our staff, all of that is funded by general fund and Title 4E funding. So I would say, I think the committee could be very helpful. And I think that there are aspects of the work that needs to happen that includes looking specifically at our capacity to draw down additional 4A funding. And that, could grow over time, but we can only draw down 4E for general fund dollars that we're already spending. And then I think the bill expands beyond that to look at other quality assurance considerations that, again, I think would be helpful to have a working group so that group could really have a level of investment and accountability around those efforts. I think it represents an opportunity to elevate the voices of people with lived experience. I think it creates an opportunity for all of us to come together around the system that we want to build for the betterment of Vermonters. And then I do want to just make one additional point that is not as much in support of the bill, but I think in response to some of the questions that have been raised over the testimony that's occurred. So I want to share, over the past decade in the state of Vermont, what our custody numbers have been. So if you go back to 2016, in the peak of the opioid epidemic, after we had 2 child abuse fatalities of children in DCF custody, we were at the peak of our number of children and youth in DCF custody. We peaked at 1,375. That's point in time data back in 2016. Every year since that time, that number has decreased. Today, we have 885 children and youth in DCF custody. So it's dramatically different, lower than it was a decade ago. That said, that entire time frame, we have been in the top 10 in the nation per capita in the custody entrance rate. We still are today. So Casey Family Programs publishes Child's Count at the national level. They use point-in-time data, September 30th of every year, to compare states across the nation. So this past September 30th, 2024, we were ranked number 7. That was true the year before as well. And so why is that? Because while Vermont has decreased dramatically in terms of the number of children and youth in custody, so has the nation. And so it's something that the Vermont legislature has expressed concern about and actually commissioned the University of Vermont to do a study on our custody entrance rate, which occurred back in 2018 and was published. Many of the recommendations coming out of that report are actively being implemented and have been a part of collaborative work done by all of the same individuals that are really providing testimony here on this bill, that what we have really looked at is consistency, who comes through the gate. Is it really necessary for a child's safety to come into DCF custody? What do we do to ensure timely reunification? What do we do to ensure timely permanence? So our rates of custody cases and other case types and TPRs, adoptions, many things follow this same trajectory. So I do think it's valuable to look at our numbers. I just wanted to at least provide a picture of hope for all to know that Vermont has made dramatic improvement over the past decade in ensuring children only come into DCF custody when it's necessary for their safety to do so. So I'll pause there and see if there are questions or anything else that I can speak to.
Questions? Ian? So going to the language of the bill, were you able to see the testimony yesterday?
Yes.
Okay, so I'm on page 2, I can hand it over to you so you can look at it. Page 2, line 15. So there was some discussion about both the 2 studies that are referenced there, and then the language of shall be consistent with versus shall consider. And I think what we heard yesterday was support for the shall be consistent with, both because the system that is described in those studies is what they think is best, and also that that would be the best way to access the 4E funds is by being consistent with the structure describing those studies. What is your take on it?
So I have read the Center for Courts publication on improvements to our court system, which generally states it's worthwhile to invest in additional 4E dollars to improve the quality and quantity of child and parent representation. So I think that general information is great.
Yeah.
I think the reality is the federal government controls those funds. In order for us to get them to give them to us, we have to do it in a certain way. And in order for us to protect those funds such that we don't have to give them back, we have to do it in a certain way. So none of the reports get into that level of detail. And really the work that needs to occur behind the scenes is more the systems that need to be set up, that need to pass muster with the Children's Bureau. Which I think will take a significant amount of work. It will not be able to be automated within our child welfare system the way it is able to be in the states that have implemented their CWIS. But again, I'm hopeful that we can create a path where we can do that. Otherwise, I just think it will take either the creation of a separate database or manual entry that is going to take some work to develop. Yeah. But all of that, I think, is beyond any of the reports that have been written thus far.
So that has to do with the 4E funds. How about just for the being held to the consistent with the structure or whatever described in those reports for the study group to?
Yes. So, the Center for Courts, the work that they've done across the nation, they do tout the New York City model in particular as one of the stronger models. And we received technical assistance in that arena. I think there's strong common ground for that approach. Again, it's the multidisciplinary approach that has peer support, right? Workers that are able to provide more intensive time with parents to help demystify the court process. And so those investments, I think we do have good common ground to move in that direction. To me, it's more, if we can bring in additional funding for Vermont, I think the committee can be held to task to say, where is there common ground for what we agree? We'll have quality improvement measures, and there's plenty of room for that common ground to be developed.
So do you think your good with the language as it's proposed with the guardrails that the shall be consistent with language creates?
Yes, yeah, yes, I do.
Thank you.
So if you hadn't a chance to, did you work at all on this language before? Did you get a chance to
No.
read in on this language?
No,
I guess, it sounds like we definitely need to do this kind of study. I understand from Marshall, there's concerns of whether we need it, but I think I'm past that part that we probably need it. But, I'm just trying to think of, I guess more, Marshall, from you, maybe more so than from DCF, from Brenda, are there particular parts of this that are most concerning? Because some of these things seem innocuous to me unless I'm missing something.
Our main concern is not the components of the study. It's that the study sets us back. As far as we're concerned, we're working with a private organization that is telling us, and they convincingly so because they're doing it in other jurisdictions, that they can do the parts that DCF can't do. They can take responsibility for the federal reporting, take liability for any errors in federal reporting, and do that by taking just a percentage of the money that we would receive. And that's something that we would have to negotiate. And we actually sort of took a break from our progress with them for the legislative session because it's basically me and Matt working with that organization. And we don't have time to work with them while we're doing the legislature.
Right.
So we're still in email contact with them. Our anticipation would be that starting when the legislature starts to wind down in May, we're back to being in regular moving forward with them, and that we may be in a position to be able to draw down federal dollars within the year. Our concern would be that this creating a committee around that is actually just going to slow the process to a halt, because whenever you create a committee and say we want everybody to agree on how this is going to go, it takes a long time. We're already at the point of us having provided them all of our information, them having told us, here's what you're going to need to do internally in order to make sure that we can report accurately to the feds. You're going to need to be able to keep track of this, keep track of this, keep track of this in terms of identifying what eligible activities, which of our staff are engaged in, and which of our OPS line expenditures are reimbursable, can be submitted for. They already told us how to do that. We're in the process of implementing that. And our expectation would be that if everything that they're saying is true, that it could be a year, 18 months, and we could be in the position to draw down these funds. Whereas if instead, we create a committee and say, okay, that process is stopped and now we're going to start a whole new.
Why would we have to push out that process? So that I guess,
I'm not sure that that organization would be interested in working with they work with public defense agencies to draw down foreign funds. I'm not sure that they would be interested in working with committee. I'm not sure that that would be part of they approached us because this is what they do, is work with public defense agencies all over the country to draw down foreign funds for child welfare services.
but I guess for DCF, why is that not good enough? Why do we need this? I'm still trying to get to understand.
so Title IV funds can only be drawn down by the state's statutory child protection agency. And those funds are tied up in all the other funds. And there are consequences. So it is DCF that gets audited on Title IV.
Right.
And DCF gets penalized if Title IV rules are not properly followed. So whatever we set up needs to be done in collaboration, needs to run through DCF funding wise. And I think that it's really, I think it's significant that it's 2025 and these funds were available in 2017. And again, I think having a cross-agency and a cross-department accountability to get to the other side of this is a valuable thing.
Okay. I think that we're probably running out of steam here, but Bill, are you still with us?
Thank you very much.
Hello, Bill? Oh, Bill, are you?
Maybe he thought we were on a break.
You're still with us. You could unmute yourself. All right, so. All right, I appreciate. I think we will rely, Bill, on your written testimony. And
We can always reschedule as needed.
if we can reschedule if needed. So we are adjourned until.
Can you hear me? Can you hear me now?
Yeah. Bill.
Sorry.
So.
Let me just,
So close.
I had planned on cutting most of my testimony and keeping things very brief based on what you
go
heard
ahead.
yesterday. But I let me just cut this off. Obviously, the testimony today from the Defender General's office was very in opposition to much of what was said yesterday. I'm puzzled because I've been working with Larry for many years and have steadily consulted with him, and he's called me about cases where parents begged their attorney to represent them, and the attorney quit, and they got another attorney, and that attorney quit. Cases where a mother or parents were being charged with the father they were having a party in their rec room, and the daughter acted out, and the father dragged her by her hair across the cement floor and up the stairs, and the parent said to their attorney, here's 5 people of our neighbors that were there and can tell you that's not what happened. And not only that, there's a carpet on the floor, but I took her by the elbow and she had a fit and was cursing and swearing, and took her upstairs and told her to stay in her room until she could behave herself. And here's 5 witnesses, and the attorney never contacted them. Or another case, at any rate, just numerous instances where there were problems with representation. And I talked with a couple of attorneys, one of whom was retired and who I know from my work at SRS back, who was working representing kids, and was just brilliant. And her comments were that the office would try to be helpful, but the training was not adequate, and felt that there were issues with pay and with caseloads. So it's difficult when you hear completely opposite stories. And I'm a little puzzled as to how to, where to go from that. I know that Larry tried to contact the Defender General and asked to meet and didn't get a response. And that Bud Allen, who's now the chair of the board of directors of VPRC and a former Defender General, called the Defender General's office to say I'd appreciate a phone call, and never got a response. But I'm not sure that getting into you folks don't adjudicate mud throwing contests.
Right. So I think so Bill, we can rely on your written statement as well. And what I am kind of hearing from all this is that we probably need a committee to be looking at this, and we need to just look at the language a little bit more, since we're hearing some different viewpoints on this. So I appreciate that. Yeah, we're not going to, there's different viewpoints on different sides here of what's going on out there. And this committee is kind of set up look at that, or maybe we need to have it do that a little bit more in addition to recommendations, but there seem to be issues that need to be addressed here. And I think that that's what we'll do as well. So as we're continuing to look at this and dealing with Larry, Chris and other folks, we may need to reach out to you again, Ben, Bill, but I think that at this point, we need to kind of sit back and kind of continue to think of what this committee would look like.
Yes, yes. And you know, I'm a big fan of, I think the idea of if you decide what you want to do, I think a work group as small as possible. I'm not a fan of mob scenes. As small a group as possible to pull together specific recommendations and recommendations for specific legislation is the way to go. And I guess the only thing I'd say aside from that is that over the years when I was commissioner, I used to look forward compared to my counterparts in other departments with when the legislature was coming back to town, because we always felt that if you wanted to make a difference for children and families in desperate circumstances, the legislature was the place to be. And we, in working with the legislature, we did some really great things for people in desperate circumstances in the state. I think if we can get to a good place with this legislation, I think this is another one of those opportunities for you folks. I don't think I can offer you, there's other folks like Sue Jacobs is much more knowledgeable than I am. She's probably the most knowledgeable person in the country on this issue. And I wish you well.
Well, we need your well wishes, so I appreciate that, and thank you very much. And if as we progress with this, we may need to reach out to you again, Bill. But I think it's time for us to take a week off.
Sure. Well, it's almost time for me to come back to Vermont. I'm down in North Carolina now.
Oh, well, yeah, we welcome you back. So
okay, thanks so much.
Thanks a lot, Bill, and
Thank you, Bill.
we will adjourn until, what's the date? March the 11th,